Hello viewers, welcome to our channel. My name is Namita and I'm a knowledge manager for IMC Group. In this video, I'm going to discuss the concept of intellectual property rights and what forms part of it. So let us understand the meaning of intellectual property rights. Intellectual property rights, that is IPR, are the legal rights that aim to safeguard the creators and other producers of the intellectual goods and services, such as inventions, literary, scientific work, artistic work, appearance of product, symbols, and signs, among others. Intellectual property rights basically offer the creator an exclusive right over the use of his or her creation for a specific period of time. In other words, intellectual property rights allow the owners to reap the benefits from their work. Besides, it entitles them to prevent others from using, tampering, or dealing with those creations without obtaining prior permission from them. In fact, it gives them the right to legally sue the person and compensate for any damages. Now, moving forward, let us see what forms part of intellectual property rights. In most countries, there are 4 primary types of IPs that can be protected. They are trademark, copyright, patent, and industrial design rights. We shall now briefly discuss these primary IPs. So let us begin with the first type of IP, that is trademark. A trademark is a sign or a combination of signs that includes symbols, words, phrases, pictures, shapes, colors, designs, or sound that give a unique identity to the goods or services of an enterprise and distinguishes it with that of others. Few examples of trademark are: the McDonald's Golden Arch is an example of a symbol trademark, Nokia's jingle is an example of sound trademark, and the 3-dimensional mark on the Coca-Cola bottle is an example of the shape trademark. Now, in order to fall under the law protection, a trademark must meet the following criteria. It must be distinctive, it must be in conformity with public order and morality, it must not be deceptive, and it must not be descriptive. Upon registration, the registered owner gets the right to use the symbol R along with their mark. The mark is registered usually for a term of 10 years, and this can be renewed by paying additional fees. The second one is copyright. A copyright protects works of human intellect. It relates to literary and artistic creations such as writing, painting, sculptures, architectural works, music, cinematographic works, as well as technology-based works such as electronic databases and computer programs. A copyright protects the expression of an idea and not the idea themselves. However, these ideas have to be original, meaning they should be created independently after applying skills, judgment, and labor. Copyright subsists of a variety of length in different jurisdictions. It usually ranges between the life of the author plus 50 to 70 years. In most of these jurisdictions, and as per Berne Convention, it is not mandatory for a copyright owner to register their copyright with the authorities. However, most countries have a voluntary registration process in place which facilitates to resolve dispute over ownership. The third one is patent. A patent is an exclusive right given to the inventor or an applicant to prevent others from commercially benefiting from the patented invention without obtaining prior permission. However, the right is granted for a limited period, which is usually 20 years from the date of filing of the application. Patents can be granted for inventions related to the products and processes. In order to fall under law protection, a patent must meet the following criteria. It must have novelty, It must involve inventive steps, that is non-obviousness, and it must have industrial or commercial application. Examples of patents include the invention of electric light bulbs by Thomas Alva Edison in 1878, the invention of telephone by Alexander Graham Bell in 1876, and invention of Bluetooth by Jat Hartson in 1994. For the avoidance of doubt, please note that patent rights are not automatic. The next one is industrial design rights. Design rights protect the way a product looks. It is basically the right granted to safeguard the original, non-functional and ornamental features of a product. Design rights concern only the product appearance, that is the aesthetics and ergonomics, that is ensure the design of a product and not the product itself. Design rights can be granted for the visual features of the product, that is pattern, graphics, shapes, configuration, ornamentation, colors, etc. In order to fall under law protection, a design must meet the following criteria. It must have novelty. It must have individual character. In most of the countries, a design needs to be registered in order to be protected. Apart from the above mentioned primary types of intellectual properties, geographical indication, trade secrets are also types of IPs. So this was about intellectual property rights and its types. The bottom line is, IP Act aims to encourage inventions and innovations by ensuring that the ideas or the creations only benefit the owner and no one else. Hope this session was useful for you. For further information, you may get in touch with IMC Group. Thanks for watching this video, and for more such updates, subscribe to our channel. Thank you so much.